I think it is clear to believe in the power of ideas.
Fresh thinking to the Manhattan Institute.
To start with, we've got Professor Daniel Richman, who's the Paul J. Kellner Professor of Law at Columbia Law School, where he teaches federal criminal law, criminal procedure, and evidence. He was a professor at Fordham Law School previously from 1992 to 2007. Before that, an assistant United States attorney at the Southern District of New York. He's a graduate of the Yale Law School and clerked for Judge Wilfred Feinberg here on the Second Circuit and Justice Thurgood Marshall. Following Professor Richman, we'll have Michael Miller, who's a partner at Steptoe & Johnson, where he's also the co-managing partner of the New York practice. He's ranked in the New York commercial litigation. He's ranked in New York commercial litigation by the Chambers USA Survey of Americans' Leading Lawyers. Before private practice, he served for 8 years in the Manhattan District Attorney's Office as a graduate of Georgetown Law School. After we hear from Mr. Miller, we'll go to James McGuire, who's a partner at Deschert, a former associate justice in the First Judicial Department of the New York Appellate Division, and a former justice in the 11th Department of the Supreme Court of New York. He was formerly also the chief counsel for New York Governor George Pataki and a graduate of Cornell Law School. And then finally we'll hear from Gerald Lefcourt, who's in private practice and has represented a number of high-profile defendants, including Abby Hoffman, the Black Panthers, and Russell Crowe. He is the president of the Criminal Justice Foundation for the National Association of Criminal Defense Lawyers. He's also the Speaker of the New York State Assembly's, he's the designee of the Speaker of the New York State Assembly, Sheldon Silver, to the Statewide Commission on Judicial Nominations. He's been listed in Super Lawyers every year since 2006, is a graduate of the Brooklyn Law School with an LLM from NYU. So, Professor Richman.
Thank you. Let's see. I think my job here is first to have a broad overview, 60,000 feet of the overcriminalization topic, and then move it towards the Martin Act, about which I think there are people who know a lot more here today. So the first question that James Copeland raised could take years to discuss, which is overcriminalization. What do we mean by it? And just want to start by reminding everybody that this is an incredibly hard topic to define. It's certainly, we understand it as over recourse to criminal sanctions. That's easy. But what one means by that gets really hard and I think politically contestable. Certainly, I think we mean over recourse to the creation of criminal laws where they ought not to be, and of course what should be criminalized and what not is going to be contestable. Then there's the question of there are criminal laws that make perfect sense but are used in service of grander projects that probably should be sought after in better and more effective ways. And again, politics here makes a big difference, and I'm sure people disagree, but illegal immigration, one might want to criminalize illegal immigration, illegal entry into the United States, but using criminal prosecutions to deal with this problem, and just remind you that constitutes 40% of the federal criminal docket in the United States, is really odd. Similarly, lying to a federal official. Easy to understand that as something one might want to criminalize, particularly if it's in the context of a federal investigation. But when should those cases be brought and to what end? Also raises issues of overcriminalization. So having sort of problematized the topic, I understand that we're all here with a rough idea of what our focus ought to be, which is of a system that certainly exists on the federal side and cuts into jurisdictions, including New York, where we have really broad laws and prosecutors with an amazing amount of power and lack of specificity about what they ought to go after and with what intensity. And sort of step back and both talking about the federal side and all contexts. What are the, New York included, what are the causes of overcriminalization? I'll just sort of throw out some topics, sort of some causes. First, of course, is the lack of a real clear understanding of what should be criminal. And we all take that for granted as a problem in the United States, but I've gone to all these conferences. The Germans think they have conquered this problem. The Germans know what should be criminal and what should not. And just to make sure, they have really given their intellectuals, their academics, oddly enough, real sort of sway in this elite world. They will tell you what should be criminal and what's not, and it really avoids the problem. So this is a pitch for you to let academics rule the world. Or rather, a pitch to just the oddness of the American system, where criminalization is what we do when we think something is really bad. If it's just a little bad, we'll regulate it. If it's really bad, we'll criminalize it. So that's part one. Part two is we have strong norms of prosecutorial discretion. Again, very unlike the Germans. It's not that I think the Germans are comparators that we ought to emulate in any way, frankly. But it's nice when thinking about our system to realize there are other ways of doing things. We have strong norms of prosecutorial discretion, which of course allow legislators to be particularly sloppy in their legislative drafting. If you criminalize something without real attention to detail, and your statute runs the risk of going into problematic areas where prosecution would be deemed inappropriate down the road, it's not really your problem. It will be the prosecutor's problem. She'll be blamed for it. You probably won't. If you add, then we make it even worse. We have plea bargaining, which really dominates our adjudicative system. It's a world which really shifts the attention away from what is denoted as criminal, what the content of criminal law ought to be, because we rarely have to take our criminal laws out and show them in a public way to a jury or even to the public. We process things behind, it's not closed doors that are open, but no one cares. Our criminal statutes are, for the most part, just a series of tariffs that prosecutors can assess, and the content of them becomes less important once they become tools of prosecutorial power. And again, the gap that we overregulate, this isn't a pitch against the United States Constitution, but we have a whole lot of attention to process when it comes to constitutional law and the way we talk about what's right and what's wrong, and very little attention to substance. So in other words, if you're a legislator, if you're a prosecutor trying to steer the legislature, if you want to reduce the cost of prosecutions, you can't play around with procedural rights, but you can increase the expansiveness of substantive law coverage. That's why you get rid of mens rea. That's why you penalize burglary tools rather than just burglary itself. We use substantive law as a way to subsidize our underinvestment. We try to do criminal law on the cheap, and it really has consequences, as I think we'll see. Then we have the vagueness of statutes in of themselves. And this is something that's particularly true in the white-collar era, which is odd when you think about it. Not odd, it makes sense, but it's, the drug statutes have many problems with them. The severity, the way we try to accomplish things with them that they're not fit to accomplish. They're not vague. They're pretty darn clear. You know what's criminal and what's not. And even to the extent they aren't clear, we take them out and we use them regularly, and courts will work out the edges pretty quickly on drug statutes or on all, extortion, murder, those statutes. Not the case in white-collar crime. We have a combination of vague statutes that are rarely taken out for a real litigated walk. I have a student who wrote this lovely paper on the Martin Act that we can discuss. There are no cases on the Martin Act. We can sit and talk about what we think the Martin Act means. There's 6 cases, 7 cases. We can read them. We can opine on them. Maybe the answer is we should prosecute a whole lot more Martin Act. I know that's not what I'm here to be pushing, but that would be one solution to the problem. And of course, the consequences of prosecution in this area are going to be so great that they're not going to be litigated. Then, of course, oddly enough, we've made criminal law a sweet spot. We've underregulated criminal law and overregulated civil regulation when you think about it. Try to get political capital to regulate during a boom economy. Or even during a down economy. Regulation is not popular, not in this room, not in the United States generally. We will fund criminal prosecutors, which is really strange when you think about it, that the weapon of choice, if you're concerned about a problem, is probably going to be underfunded if you turn to the civil side, and is going to be well funded with discretionary power behind it if you turn to the criminal side. That's strange. So that's sort of the overall tour of some of the grand themes of overcriminalization. Just to bring it down quickly, and I think I'll have 1 minute to the New York side. It could be worse here, obviously, because we have weird creatures in our criminal statutes here. We have elected prosecutors abounding. The good news is we don't have the money. The good news, and we have real crime. DAs may be elected and may have all sorts of political ambitions, but if you're going to go after rapes, robberies, and murders, you don't have much discretionary spending left. So no matter what kind of interesting white-collar animals you dredge up from the New York penal statutes, you don't really have to worry about them being used for the most part by DAs across the county. The AG, of course, doesn't have, the New York AG, a little different, doesn't have that sort of responsibility. Has the Martin Act and other statutes, not a lot, but enough that really give him the ability to drift. Now, I don't want to so this isn't a purely overcriminalization problem. I mean, a lot of the things that Elliot Spitzer did were civil. And let's remind ourselves that a civil complaint filed against a publicly traded company is a serious matter and probably will have a lot of the repercussions that a criminal indictment or even a misdemeanor complaint would have. So in a way, some of this is for another panel and not for this, if you want to just talk about overregulation or the weirdness of American regulatory strategies. Just to end, I think, what we have in New York, particularly with respect to the Martin Act, is regulation on the cheap. And again, cheapness really is a big explanation for what's going on here. We could zero out the AG's responsibilities in the Martin Act or radically tool up the Martin Act. They would go someplace. Maybe they should go to the financial czar that the governor has. Maybe they should go elsewhere. But politically, you're not going to zero out regulation in the financial area. If you are going to have it, what you have, and it's your choice as much as anyone else's, is under regulation for the most part, but there's broad power on the part of the AG to just interfere where he sees fit, and not even interfere in a real way. They don't have a grand trial capacity in the New York AG's office. They can talk about trial. And where I want to end and where to pick this up is it always amazes me that if you ask, people in New York ought not to just sit there fearing that they're going to be prosecuted for things that just they couldn't imagine are crimes. I don't, we can have this discussion for a long time. I just don't think that's true if you look at what cases are actually brought. If you ask, though, a lawyer, your lawyer, is what I'm doing a crime? That's hard. It's really hard to sort of talk to a client, and I actually have tried this, sort of explaining what the law says, what exactly is criminal. And that's a weird place to be, and I think in our own ways, depending on our political valences, we've contributed to it. So don't just blame the people in Albany, although we should too.
Thanks so much. Mr. Miller.
It's very hard to go after an entertaining discussion about depraved indifference and sex and the thoughtful comments of Professor Richman, but here goes. So there's a broad perspective on the issues that we're talking today. I guess I've been tasked with taking the somewhat contrarian view. If the question for the panel today is whether there is overcriminalization in the Empire State, with caveats, and I've got specific ideas of things that we could be looking to do to change the existing statutory structure. I think there's a lot that New York State is doing that makes sense, and while on an individual case I'm an aggressive advocate for the interests of my client, I think if the question is, do we need to significantly ramp back the amount of authority that's available in New York State, I actually do believe the answer is no. Let me start at the end, and then I'm going to go back and sort of cover some of the reasons why I come out there. I do think that there are some very fundamental issues that we can look at in the New York State system that will go a long way towards leveling the playing field. I think the fundamental problem with any statutory structure, whether it's in need of being fine-tuned or not, is that individuals, human beings, make the decisions about when and where and against whom to use those statutes. That injects a degree of fallibility. The whole issue of prosecutorial discretion is subject to abuse. It's subject to fallibility. It's subject to one individual having X as a very, very high priority while another has A, and perhaps even some people having a fair amount of self-interest work its way into the prosecutorial discretion process. So no matter what you do with the underlying substantive statutes, I think there's a really pregnant question that exists in the New York State system, and it's not unique to New York. It never ceases to amaze me how, if I represent a client in a dispute over $100,000 or $1 million or $10 million, I can take discovery that just stops the trucks. I really can get into the hearts and minds and bank statements, and the amount of discovery you can get in a civil dispute is astonishing compared to what's available in a criminal case. There is no, this may be an overstatement, but there's no degree of prosecutorial abuse or failure to sort of toe the line in terms of using prosecutorial discretion in a way you can feel comfortable with that ultimately isn't susceptible to being disclosed if defendants have the ability to take meaningful discovery. And for those of you, and I know many of you in the audience who are active practitioners, you know exactly what I'm talking about. The process of getting any meaningful third-party discovery, whether it's in the federal system or in the state system, it's a Herculean task, and in my view, vastly disproportionate to the exposure that individual clients have if they're convicted. So let me go back to sort of my opening observation, which is I think New York State, while it doesn't have it exactly right, has a place on the playing field and should be doing the things that it's doing. Obviously, New York State is a unique state. New York State is the home to, it's our financial capital. It's where our largest banks are located. It's where our most sophisticated traders, however much money they may lose in the blink of an eye, our most sophisticated traders are here. Our exchanges are here. We have a large insurance industry presence here. We have, a vastly shifting but very substantial array of very important businesses that call New York home. And there's no other city in the United States that's like New York that way, and no other state in the United States like New York. I think, as a personal matter, that New York State has every right to have a significant regulatory and criminal presence, given what it plays home for. Who basically chooses to be here. Second, there's been a clear role for state regulators and prosecutors. I mean, folks can have a genuinely interesting conversation about how these investigations were conducted and whether the ultimate results were the right results. But there have been a number of examples where federal regulators and prosecutors have not focused on topics that ultimately were seized on by state and local prosecutors and regulators. And some of those examples, going back to my era in the Manhattan DA's office, there was the BCCI bank case that was brought by Robert Morgenthau's office. We've all seen, for better or for worse, the mutual fund market timing investigation, the investigation into the relationship between investment bankers and research analysts. A lot of these were issues. We can really have a good discussion about whether the investigations were run properly, and for those of us who represented folks in those investigations, they were pretty bruising investigations. But there wasn't much happening on the federal level when those investigations started on the state level. So as a practical matter, we've seen that there is a clear role for prosecutors and regulators on the state level. Let me talk briefly about the Martin Act, and I think that's a topic that Jim McGuire and I are going to probably focus on primarily. The Martin Act, and I'm going to have three very specific proposals for the Martin Act, but the Martin Act is I think, a fundamentally sound statute.
Repeal it first? No.
Well, number one, repeal it and rewrite it the way Jim would like to rewrite it. It was one of the first blue sky statutes enacted in the U.S. back in 1922, I think was the year it was actually finally enacted. So well before the 33 and 34 Acts. It has evolved over time. It has taken on a greater role in terms of it. The criminal piece of it has taken on perhaps a disproportionate role in terms of its use. For a lot of years, it was used primarily for real estate syndicate work, which is another topic for another day that I know nothing about. It's designed as a remedial statute. From day one, it was designed to basically protect the interests of investors. So it was designed to be liberally interpreted. It was designed to have broad definitions. It was designed to broadly define fraud because there was a perception then, and I think it carries through to today, that fraud is a hard thing to define with particularity without inadvertently defining conduct that you'd otherwise view as illegal outside the four corners of fraud. You see the same debate over many, many years in the federal system in the context of how to define insider trading. It does have a misdemeanor provision with no mens rea requirement. That is a very unique creature. I will say that as a former prosecutor who brought a lot of Martin Act prosecutions and as a defense lawyer who's represented clients who have been the subject of Martin Act prosecutions, I don't see that misdemeanor provision surfacing even in behind closed door discussions. Most prosecutors who I've dealt with, both in the Manhattan DA's office and the New York State Attorney General's office, at least in my experience, and others may have had different experiences, if you don't meet the intentional fraud requirements for 352C5 and 6, which are the felony provisions in the Martin Act, they're not talking about a Martin Act prosecution. So perhaps one of the things that we could talk about changing or thinking about whether there's a viable role for it going forward is that provision. But as a practical matter, I don't see it really surfacing in cases that I've been involved with. I think one of the most striking things about the Martin Act, when you think about overcriminalization as a broad philosophical question, is the sentencing structure that's associated with the Martin Act. If you flip through the New York State penal law and you look at statutes old and the condensed version, this is without annotations. If you go through, maybe this is the best evidence for the overcriminalization. If you go through and look at statutes, old and new, the old statutes like grand larceny and criminal possession of stolen properties, and look at some of the more current ones like healthcare fraud and mortgage fraud, the New York State Legislature has methodically established a hierarchy of sentencing exposure that is correlated directly to the amount of money that's involved. Okay, so if you steal $100, you're not even talking about a felony unless it's under other circumstances. If you're talking over $1 million in larceny, you're talking about a 25-year exposure. Under the Martin Act, the maximum exposure, the highest level felony under the Martin Act is an E felony. So the maximum exposure is 1.5 to 4 years in prison. So that's really interesting because the Martin Act has enormous potential for forcing people in the industry to evolve, much in the same way an aggressive SEC or DOJ investigation has. But in terms of actual exposure to incarceration, the Martin Act as a fraud statute is really unique in the New York State system for its limited sentencing structure. So that's my defense of the Martin Act. Let me propose 3 thoughts that I think might make for sensible amendments to the Martin Act. One of them, and I will give a nod to Marjorie Pierce, who's here, for putting this one in play earlier, but she's 100% right. The Martin Act, as it stands right now, has some very curious language which prohibits individuals from revealing to other individuals the content of their discussions when they're being formally interviewed or examined by the Attorney General's office. That is a restriction that is not consistent at all with grand jury practice in the New York State system. If you were to appear before a grand jury that the Manhattan DA's office had convened, or a federal grand jury that in Dan's old office, you'd have the right to walk out, go up to the microphone, and describe exactly what you said before that grand jury. So this language is very unusual. It's not clear that there's an independent, valid reason to continue to have that language. And I think most people who practice in the Attorney General's office, in my experience, don't even enforce it or follow it. That's one thing that could change. There's also language that suggests that individuals who are examined by the Attorney General's office are not entitled to counsel during that examination process. During one particular administration, I saw that threat advanced with great regularity. He's no longer the Attorney General. His 2 successors you have no idea who I'm talking about, right? I, in my experience, have never asserted that is a condition for walking in the door and talking. And lastly, and this is just keying off of Jim's excellent New York Post article. Jim does point out that under the Martin Act, there is this false promises concept, which, in his view, creates enormous exposure for executives who are offering opinions about what the future holds. And creates exposure where there's a promise or representation as to the future which is beyond reasonable expectation or unwarranted by existing circumstances, and that's pretty fuzzy language. The New York State penal law under grand larceny, there's a whole rack of statutes that define what is grand larceny, has a false promises concept. I think if you were to tweak this as opposed to eliminating it, because I think you do have to have some criminality, or potential for criminal prosecution in the event of intentional misstatements about the future. This language may be a useful, at least starting point. So false promises are defined under the penal law in section 155.05(2)(d). A person obtains property by false promise when, pursuant to a scheme to defraud, he obtains property of another by means of representation express or implied that he or a third person will in the future engage in particular conduct, and when he does not intend to engage in such conduct, or as the case may be, does not believe that the third party intends to engage in such conduct. And the definition goes on from there and actually refines it to some extent. So that is a potential place to start. I'll wrap up my comments simply by going back to that broad observation, which is I do think the great leveler in litigation is discovery. And if there is one fundamental flaw that I see every day in the federal and state system, and since we're focused on the state system, I'll focus on that in the New York State system, is the inability to conduct meaningful discovery in criminal cases and the vastly disproportionate advantage that prosecutors have in that respect.
Fantastic. Mr. McGuire.
Mike and I were colleagues in the Manhattan DA's office a long time ago, and I'm happy to play the role of prosecutor of the Martin Act in response to Mike's defense of it. Rousing and significant as it was, and as I prosecute it, I will certainly make use of the full arsenal of strict liability offenses that I can employ. But the first thing I want to say is that it's really all Judge Smith's fault, and that's because he's been on the court now for I think it's 9 years or 8 or 9 years, and he's right. He hasn't construed the felony provisions. The court has not construed the felony provisions of the Martin Act. And unfortunately, another panelist here is also culpable, and that's Jerry, because as the longest-serving member of the Commission on Judicial Nomination, the body that recommends the candidates for the governor, I think you're going to plead guilty to the strict liability offense of not securing a promise from Bob that he would do the impossible and guarantee that they could be construed. I think ultimately it doesn't really matter, and this is harmless error because there is the felony provisions of the Martin Act have been construed by a panel of the Third Department. There have been other lower court decisions, and it was an opinion authored by really one of the best appellate division judges in the state for the last 20 years or so. I'm sure Bob Smith would agree. Tom Mercure, who is currently the presiding, no, he's not the presiding justice, he's up for the presiding justice, but he's a great judge there. And I just want to read from what he said there, and this is a case called People versus Sala. It did go up to the Court of Appeals, and it was affirmed, but the court really had no occasion to discuss the elements of the 352 sub 6, C6. And he said the following, citing many cases throughout, I'm not going to bore you with the citations, quote, moreover, contrary to defendant's contentions, neither scienter nor an intent to defraud need be proven in order to establish liability under the Martin Act. And he is talking specifically about 352 C6, one of the two felony provisions. Rather, The people need only prove that the defendant committed an intentional act constituting fraud, which under the Martin Act includes all deceitful practices contrary to the plain rules of common honesty and all acts tending to deceive or mislead the public. And I like to focus on this language of contrary to the plain rules of common honesty. Judge McGuire didn't pull that like nitrogen out of the air. That came from many cases, including Court of Appeals cases that were decided when the Martin Act was not a criminal statute. I think, I submit that a statute that penalizes acts that are contrary to the plain rules of common honesty is basically making criminal liability turn on a moral question, and I think that's profoundly problematic. So to follow up on that, I think Walter Olson of the Cato Institute had something to say about the Martin Act, which is worth mentioning. I have it here somewhere, and I think it's a pretty concise statement of the statute's biggest flaws. And he wrote that the Martin Act was turned by stages, quote, into a blank check for the prosecution. Under its terms, the Attorney General can subpoena witnesses or demand the production of documents without probable cause or a grand jury say-so. He can sue anyone for alleged fraud without showing that anyone relied on the alleged misrepresentation to their detriment, and astoundingly, without even having to show a guilty state of mind or intent to commit fraud. In this, the Act goes far beyond the federal securities laws and common law. Moreover, the law gives the AG almost total discretion over the public release of one's private documents and testimony, a perfect weapon for trying cases in the press. To top it all, targets of subpoenas do not enjoy rights against self-incrimination or even a right, as of law, to have a lawyer present. So I'd be interested in what Michael may have to say about that, but I don't think that account of the Martin Act can be really reasonably disputed, except perhaps about the margins. And obviously it raises some pretty profound issues, including constitutional vagueness and notice issues. And with respect to the vagueness part of it, I note that, as Elkin Abramowitz and Barry Bohr pointed out in a Law Journal article, that with respect to the Hank Morris prosecution, that was an article that had high hopes that would eventually get appellate review by the Court of Appeals. It didn't, because it was a plea of guilty by Hank Morris. More on that later. But the Attorney General found in the Marking Act lurking in it lo these many decades really what amounted to a theft of honest services prosecution. And I will just say, I won't get in the subject in any depth now, that it's pretty hard to read the Martin Act against McNally and the Skilling decisions by the Supreme Court and conclude that it does not have, at the very least, substantial vagueness problems that could invalidate at least the Martin Act in significant part, or theories of it. Whether there's a core of the Martin Act that the court could fall back on, as the majority did in Skilling, is also something that's not altogether clear to me. I'm not studied enough to take a position on it. But I want to touch on another aspect of the Martin Act in this regard, one I think that has gotten less attention, and that is whether it really can be reconciled with fundamental principle of American democracy, which is separation of powers. And if, as I think is true, the Martin Act is an empty vessel into which the Attorney General can pour, whatever content he wants, what does that mean? Well, doesn't it really mean that an executive branch official, and to boot, not even the state's chief executive officer, is empowered to exercise a legislative function, the legislative power to declare the law? And there's another aspect to that too. There's been some attention devoted to the efforts by Attorney General Spitzer to use the Martin Act to transform the business models of investment banking and insurers. There's a separation of powers aspect there too, with respect to both branches. We ordinarily think that changing the business models of organizations is a policy question for the legislature, but it's also something that I think is in tension with the supervisory authority of the executive branch agencies, banking and insurance most notably, and now the authority of the consolidated banking and superintendent. Those two entities, as you know, are consolidated, and happily, I know one person in the room agrees that the new czar, he's a friend, as I like to call him, is a highly responsible official. But the point is that there's an element of intrusion on separation of powers in that regard too. But that's not all, because I think it also entails an erosion of judicial power. Because when the standard of guilt is so nebulous, when it turns on whether the defendant's conduct, quote, comports with, quote, the plain rules of common honesty, an important question has to be asked, and that is, how can the judiciary meaningfully review the sufficiency, let alone the weight of the evidence, when it's being asked to review what amounts to a moral question? It really harkens back to the days before the model penal code, where guilt did commonly turn on broadly phrased statutes, which were based on common law antecedents. And the model penal code was an effort to really try to bring some rationality to that system with structures of liability and in large part statutes that were founded on a mens rea component and gradations of responsibility based on the severity of the mental state. And those are features that are notably lacking from the Martin Act. The absence in the felony provision of really any scienter in any significant sense. I mean, yes, an intentional act, but it's not an intent. It doesn't require. There are provisions that permit the felony prosecution with an intent to defraud, but as Judge McGuire's opinion makes clear, there need not be an intent to defraud in the sense that the common law defined it. So, a couple of words about another aspect of the statute, and that's its coerciveness. And yes, it's a low-level felony, but it is nonetheless highly coercive, and I think it's a direct consequence of its extraordinary breadth. I think that there's probably few who would disagree that for many a financial institution, or it could be another business enterprise, merely being indicted for a felony can be tantamount to a corporate death sentence. Now, suppose the legislature passed a statute that made misdemeanor larceny a felony under the following circumstances. And I'll follow Bob's illustration of depraved indifference, because he knows I am not in wholehearted agreement with him with respect to depraved indifference. But anyway, my hypothesis is a statute that makes the misdemeanor larceny offense a felony when it is committed under circumstances evincing a depraved indifference to common honesty. And suppose, too, that the legislature specified that upon conviction of that offense, the defendant was subject to a sentence of 6 years, or, with the consent of the Attorney General or the prosecutor, a fine of $1,000. Well, I think there'd really be a hue and a cry about a statute like that, and I think the hue and cry would focus in part on, doesn't it threaten, if not vitiate, the right to a jury trial, the presumption of innocence, and the requirement of proof beyond a reasonable doubt? And many people have talked about the appalling lack of jury trials here, and it's in part because of the coercive fabric of the criminal laws in general. Sometimes that's perfectly proper and perfectly appropriate. It's just a necessary consequence of criminal laws. But I think the Martin Act goes too far. And in respect to my hypothetical, I think you'd also say that the public would not be likely to have much confidence that someone who was faced with that choice, go to trial, maybe get sentenced to 7 years, pay $1,000, that they plead guilty. It's hard to think the public would really have a lot of confidence that those who did plead guilty pled guilty because they were in fact guilty. And so the question, of course, that this all leads to is really, given the reality that the threat of an indictment under the Martin Act for many an institution can be a corporate death sentence, whether the Martin Act can fundamentally be distinguished from the hypothetical statute that I just passed. So I don't have a heck of a lot more to say, but I'll finish with a statement made by Eric Dinallo, who at the time was the chief of the Attorney General's Investor Protection and Securities Bureau, at least when he wrote this article. He was later an unsuccessful candidate for Attorney General, losing to Eric Schneiderman in the primary, as I'm sure you well know. And he said the Martin Act is, quote, one of the broadest anti-fraud statutes ever devised, at least in a democratic society. I think the first half of that statement is unquestionably true. And I don't mean to suggest that we don't live in a democratic society, but I do want to point out that I think that the democratic society that our framers envisioned is one of separation of powers. And indeed, separation of powers was really regarded by Madison in particular as really the key to freedom, because it was rightly recognized, I think, that it was essential to a rule of law and not a rule of men. I'm not on the bench, so I could express opinions about certain predecessors to the Attorney General, but I will forbear from doing that. But I think that at the very least it's fair to say that in prior administrations, more than two back, there was a question about whether or not we really had, at least with respect to the Martin Act, a rule of law rather than of men, government of law rather than men. That's about all I have to say for now.
Thank you. And finally, Mr. Lefcourt.
So I'll change the subject and admit that I gave money to Cy Vance's campaign for district attorney. That's a radical thing for a lifelong defense lawyer to be doing, but I thought he was fair. He was a fellow defense lawyer before he ran for district attorney, and I'm shocked that the district attorney's office has proposed a new criminal forfeiture law which does things to New York State. It's sort of worse than Me Too. I want to be like the feds. It goes further than the feds. And when I was a young lawyer and Rudy Giuliani was the United States attorney, one morning we woke up to an arrest of a bunch of people in two different RICO indictments, and unbeknownst to anyone, prior to the indictments being announced, there were ex parte restraining orders issued by district judges restraining all the assets of all the defendants in both RICO prosecutions, and they had no money to retain counsel. And that what was intended by the United States attorney. And so it got on, the argument over forfeiture. Now, certainly nobody should be keeping ill-gotten gains, but before you go to trial, before you prosecuted, you are rendered penniless by ex parte orders like that. And so the debate raged in the 80s, and finally it got resolved with some very good decisions from the Second Circuit and Monsanto and other places. And we've now worked all that out. To revisit that debate in a statute that would prohibit a defendant in New York State, because of a similar restraining order, to either use his own assets to defend himself or to live on, not only is contrary to what the New York forfeiture laws are now, but it's just shameful. And so back in the 80s, when we worked all this out, I was very active with Mel Miller, who was the Speaker of the Assembly, to make sure the New York forfeiture laws had in it provisions to allow for attorney's fees and living expenses for defendants who were subject to ex parte orders or to restraining orders in general. And now, Mr. Vance has proposed a very broad forfeiture law and has put all of this back in the news. And it's all back in the news. Recently, George Will wrote a piece in the Washington Post where he says equitable sharing, which is a federal forfeiture way of doing things, sharing proceeds with state agencies, the consensual splitting of ill-gotten loot by the looters reeks of the moral hazard that exists in situations in which incentives are for perverse behavior. To see where this leads, you should read the Institute of Justice scalding report, Policing for Profit, the Abuse of Civil Forfeiture, a sickening litany of law enforcement agencies padding their budgets and financing boondoggles by, for example, smelling or imagining to smell or pretending to smell marijuana in the cars they covet. Well, now we have a new proposal for forfeiture which would make forfeiture for all crimes in New York State, including misdemeanors, which one would have thought are not that serious. But this proposal not only seeks forfeiture for even misdemeanors, but has real property instrumentalities of forfeiture. Now, what that means, and I had one of these cases once, a man owned a Midtown building in the Garment Center and rented 2 floors to a manufacturer of T-shirts who manufactured knockoff T-shirts, and the government claimed that he knew that his tenants were doing that, and they moved to forfeit his entire 12-story office building on the grounds that it was used as an instrumentality of a crime. And the New York proposal by Cy Vance has broad real estate forfeitures as instrumentalities of crime. It also changes New York law and permits the sale of property held as tenants in common for forfeiture purposes, which one would fear could result in innocent party spouses or families becoming homeless. It has an overly restrictive federal definition of owner. And under a proposed section, the government can seize property and retain it for 90 days before granting a due process hearing, even though the Second Circuit ruled in a case called Crimstock v. Kelly that there must be an immediate due process hearing upon the seizure of property, in which one has to establish, or the prosecutors have to establish, probable cause for the seizure, probable cause for continued impoundment of the property pending trial, and that there are no less restrictive means available. So this changes a lot of law. And I'm really appalled that so many of these provisions were picked out of the federal forfeiture statutes, of which the Wall Street Journal says there are some 400 federal forfeiture statutes, using the most draconian and putting it into a new proposal. It didn't pass, but the fight is on again. I'd just like to say one other thing about what was being discussed in the Martin Act, and I've had clients subject to this. The problem is way beyond, in my view, the Martin Act, and Judge Lewis Kaplan of the Southern District gave a speech not too long ago where he said in order to prevent corporations or institutions from caving in so quickly, the reason why there are no trials, and there won't be, is because if you are an institution, a criminal charge is the death knell, is to reconsider respondeat superior liability for criminal prosecutions. I mean, because an executive commits an illegal act, should the corporation be destroyed? And one might think, and he proposed reconsidering this whole problem. When Arthur Andersen was indicted for obstruction of justice, everybody lost their job. One of the big 5 accounting firms went under, only to find out years later the Supreme Court reversed the conviction, but it was far too late. Everybody was out of their job and the institution was destroyed. The Martin Act, very much like federal mail fraud statutes, and I agree that the Martin Act is even more vague and more difficult to deal with, but it has the same effect. You could no longer, if you are in a regulated industry, take a federal indictment than you could a Martin Act indictment. The whole problem is with, the notion of this respondeat superior prosecutorial issue. Thank you.
Ms. Lefcourt, I'm glad you brought that last point up because it's something I've written on, and in the back of the packet, my 2010 article on regulation by prosecution focuses specifically on respondeat superior liability. I'm skeptical that there's going to be the political will to eliminate it, but I do sketch out some proposals that might help limit and reform some of the issues there. I want to give Mike Miller a chance to respond to Jim McGuire, but before that, I actually am going to turn to Professor Richman because there are a couple things that I heard come out in the panel that I'd like you to react to and shed light on. One is Mr. Miller's talk about discovery and the issues there, and I'd like you to frame your thoughts there, and then before we go back to the Martin Act, I'd like you to give your thoughts on Mr. Lefcourt's discussion of civil forfeiture and how you see that.
Sure. I love teaching criminal procedure to second years after they've had civil procedure because they sit through civil procedure and they learn about the enormously expansive regimes, particularly in the federal side for civil discovery, and they come into a course where the stakes are higher generally, and one would expect the world to be even better when it comes to disclosure. Then, particularly since I teach mostly federal side, ramming in their face the incredibly miserliness of discovery in criminal cases is something that makes them cry and think, which is the job of a teacher. But I got to say, even if you had an expansive discovery system, it really wouldn't address a lot of the problems. And here I do want to take on Mr. Miller's point. Discovery will let you know about the case, and it will know. The greater it is, the more you'll know about the cards on the other side. But in terms of figuring out what went into making that decision, or what you really care about is what's the story wherein I was selected out from people doing exactly the same sort of thing. You're never going to get that. I can't imagine even the most expansive discovery system that really will allow you to get a good sense of the decisions that you care about most. The decision you care about most is why they brought the case, not what the case is about. So I do want to just leave that open. And with respect to Jerry Lefcourt's point, I got to say I felt quite Burkean listening to him in the sense that we haven't worked out criminal attorney fee forfeitures in any way. It's the same law now as it was back when people like Jerry were kicking and screaming. If you are a drug lawyer, you really can't practice, and you take the risks seriously, you ought to stay with indigent clients. The only reason, and this isn't an advertisement for prosecutorial discretion, it's just the truth. The only reason that things have died down is, one, people get used to things, for better or for worse. Two, and I think this is the important point for our purposes, you let a regime run for about 20 years, discretion will start getting developed and internal norms, and though we don't know what the Martin Act is about right now, it is quite possible if you ran this experiment, odd as it is, for a couple more years, got some cases, you'd be in a very different place than you are now, because that's exactly what happened on the forfeiture side in the federal case. with a state, and obviously when you're dealing with state prosecutors, there's a whole different kind of risk than there is on the federal side, because you have county prosecutors who really aren't harnessed by under the control of any hierarchy, and if this is a quick way to make a buck, people are troubled by it on the federal side. Just wait till you watch it in the hands of elected county prosecutors. So it's not just about the laws. The laws are just the beginning of the inquiry. It's about the institutions that exercise those powers.
Fascinating. And I'd just like to say that as someone who works in this area, saying something's better than civil discovery, or you expect it to be better. I've certainly been a critic of broad civil discovery. It's certainly better from the lawyer's perspective, but I'm not sure it's better for societies. With that said, I want to turn to Mike Miller and give him a chance to offer his rebuttal, if any, on the Martin Act.
So alone up here.
But among friends.
Let me start by just commenting on the discovery point that Dan made. I very much agree that it's always helpful to understand why a case was brought and why you were singled out of the herd of antelopes for the lion to track down. But I do think in sort of day in and day out terms, there is just fundamental limitations on discovery. If you get 302 reports in a federal case, the agent sat down, memorialized the interview. Now, there may have been handwritten notes that back that up. There might be some grand jury testimony where the agent re-summarized the testimony, or maybe even the witness came in. Try and get that. And I mean, in the New York State system, you actually have a shot at getting that. In the federal system, try and get that. And you have to move heaven and earth to punch through the version of life that is reflected in the 302. That's not right. And when you finally do get through to the notes or the grand jury transcripts, it is invariably a treasure trove of meaningful cross-examination material. That's not right, in my humble opinion. Another example, third-party discovery. You want to reach out to get documents or information from a third party. As a practical matter in a criminal case, they don't want anything to do with being adverse to the government. I mean, whether you're in a very regulated industry or a sort of regulated industry or not at all a regulated industry, most third parties want nothing to do with a criminal prosecution. So you're already dealing with a less than excited third party. And as a practical matter, the government is going to oppose most of your efforts to get information from a third party unless you can establish that it's not a quote-unquote fishing expedition, that you're looking for specific evidence. So, oftentimes you may have a really strong sense that something is lurking in the files of a third party, but you can't articulate exactly what it is and where it is. Many judges will say, thanks for your time and attention, but until you can be a little more precise, I'm not issuing orders. And so I very much agree. It's useful to understand why cases are brought, but in the to and fro in the courtroom, where you're really trying to sort of establish what the truth is and trying to establish that your client, where your client sits relative to the larger criminal scheme, the limits on discovery, while they don't solve all, while expanded discovery doesn't solve all problems, the limits on discovery that exist now, if you really want to talk, at least in my perspective, of a fundamental change that would dramatically level the playing field, I think that's a fruitful topic. On the Martin Act front, just to respond to a couple of quick points on the question of what sort of intent is required under the Martin Act. Look, I'm not saying the language is perfect, but Sections 5 and 6, which are the two felony provisions in the Martin Act, Section 5 makes it a crime to intentionally engage in any scheme constituting a systematic, ongoing course of conduct with intent to defraud 10 or more persons or to obtain property, et cetera, et cetera, et cetera. So they're like it's like a double-decker ham sandwich of intent that you have to prove with Section 5. Section 6 requires proof that you intentionally engage in fraud or deception or concealment or false pretense, or you make a material false representation or statement with intent to deceive or defraud. So again, it doesn't exactly mirror the federal statutes. It's kind of its own creature, but it certainly is not a mens rea free provision. And with all due respect to Jim. He's not on the bench anymore, so I don't have to be quite so careful. But the last thing I want to say, is that a lot of the other problems that were enumerated with the Martin Act, the scope of administrative powers that the Attorney General exercises, well, so does the SEC. I mean, what they don't have is the ability to criminally prosecute if things don't go right. But if you go to the Southern District and you sit down on any kind of a securities fraud case, guess who's sitting next to the Southern District prosecutor? An attorney who's assigned over from the SEC. But the reality is the scope of administrative powers, rulemaking, enforcement, and the like, it's all there on the SEC level, too. It's not a problem that's unique to the Attorney General here in New York. The Martin Act does not require proof of reliance. Mail fraud doesn't require proof of reliance. I'd be happy to see both of those change. But the reality is it's not a problem that's unique to the Martin Act. Criminal corporate liability, I'm in agreement with everybody on the panel. I think the threshold is very low. But again, it's not a problem that's unique to New York. So if the topic today is overcriminalizing the empire state, the empire shares a lot with the bigger empire.
Certainly agree with that. I want to give Jim a chance to respond briefly, and then we'll open up to the audience.
Mike certainly is correct that there are clauses of particularly 352C6 that require an intent to defraud, but the problem is that that's an alternative theory. You can pursue other theories that are specified in the statute, and that's why Judge McGuire was able to say what he said, which is does not require an intent to defraud. It requires an intentional act and then certain other things, and that is based on the language about deceit, pretenses, etc. And as he said, it's all these practices, an intentional act, and practices that violate the norms of common honesty. So it's nothing like a mens rea as we traditionally know it. And maybe the way to illustrate that is to say, it's an intentional act for me to throw a rock in the direction of a building, and if it's got, a couple of small windows, but it's mostly brick, it's another thing to say that I intentionally smashed that window. And that's what the Martin Act requires as interpreted by the Third Department, an intentional act, but not a conscious objective to defraud, which is the mens rea that we all know and we're all so familiar with in the penal law. And that's precisely why its sweep is so profound that it really can be used. I don't want to try to be too loaded with my words, but not as a tool for law enforcement, but as a weapon, and a very powerful weapon that really, as I think we all agree, just brings businesses to its knees, because they really can't have any confidence that on what I don't think it's really much of an overstatement to say, a prosecution that can be predicated when the absence of reliance, with no mens rea as we know it, which got so much open texture, they really have to wonder whether they've got really any chance. And it's not like these institutions are invulnerable from, if not being demonized, but really being painted as bad moral actors in the first place. And a word, too, about the Attorney General, which is the Attorney General has been often observed, no constitutional, under the Constitution, no criminal law enforcement responsibilities. We all think of the Attorney General as the chief law enforcement officer, but he has none by Constitution. It's really all by statute. And the interesting thing about it is, that he's not the chief executive officer, but various of the provisions that do give him criminal prosecutorial authority are subject to gubernatorial check, which I think is a very healthy thing. He needs the consent of the governor to bring all sorts of prosecutions. Not so with the Martin Act. And it's also interesting to note that even with the elected district attorneys, the governor has a check. He has a check under the executive law, and can replace a district attorney in a particular case. But the chief executive, who has the responsibility under the Constitution to take care of the laws are faithfully executed, really does not have any such role with respect to the Martin Act, and I think that also raises some problems.
All right. Audience, again, wait for the mic, please, and then identify yourself.
First of all, I want to say that it was a wonderful panel. Secondly, my name is Gerald Wolpen. Years ago, I want to address one question to Jim, feeling that Mike needs some support on the Martin Act. Years ago, when I was a U.S. attorney, assistant U.S. attorney, I prosecuted a very large stock fraud case in which I included Martin Act charges because they fit into the indictment. And the request to charge that I gave to that judge, and a very good judge at that time, Judge Hurlins, in the Southern District, required scienter to establish, the jury must find scienter to establish the Martin Act. I note, it seems to me, and I ask Jim this question, is there really any difference between the Martin Act in substance and even in wording from 10b-5, which we know has been applied with scienter, although it doesn't say so. For example, the last phrase of 10b-5 is to engage in any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person. Now, if the courts had not interpreted it to require scienter, it would be exactly the same thing as you say the judge in the Third Circuit decided. I can only ask you whether there isn't a mistake for the judge to have so decided, and is there any real difference between 10b-5 and the Martin Act? One final question on that is to Mr. Richman on discovery, criminal discovery. You know, civil discovery, it's reciprocal. The defendant can ask the plaintiff, and the plaintiff can ask the defendant. There's a big difference in criminal discovery in that the defendant has the Fifth Amendment and the prosecutor can't ask for discovery. And secondly, with regard to 302s and grand jury testimony, that is provided under 3500. That is prior to cross-examination. And usually today it's given long prior. The defense counsel does get that. So is there really any analogy between civil that you made, discovery, and criminal?
We'll go to Jim first.
Well, I'm certainly not an expert on 10b-5. Never brought any prosecutions under it, but I like to think I'm a total babe in the woods about it. And I guess my response to you is that the difference is that the Martin Act, there are textual differences. There are similarities, but there are textual differences. But the reality is that both with respect to the misdemeanor and the felony provisions is a long history, well, particularly with the misdemeanors, of interpreting it to not require scienter. And this language that I quoted from Judge McGuire's opinion for the Third Department, again, that was drawn from many other cases that have said the same thing in construing the Martin Act, particularly the misdemeanor provisions. Now, those provisions arose and were interpreted at a time when the Martin Act did not provide for criminal penalties, but essentially the same language or similar language was used when the felony statutes were enacted in, I think it was 1982. I'm not saying that Judge McGuire's opinion is invulnerable from being modified by the New York State Court of Appeals. I jokingly said I was holding Bob Smith, who's a long-time friend of mine, responsible for it. I do think both as a matter of textual analysis and as a matter of statutory interpretation, if you're among those who think that the legislative history is particularly illuminating, I don't count myself as one of them, but if you are among that group, I think it's a tough row to hoe. But my fundamental point is that that's the law now. And the trial courts in this state, no matter where they're located, are going to be following the Third Department's decision. And so whether the Martin Act should be construed the same way as 10b-5 is a separate matter. The reality is that that those who are charged with, sometimes they're charged with it under theories that are common law fraud with intent to defraud. And so that's one of the reasons why sometimes you don't see cases under it, because the prosecution limits itself to the narrower theory. But the problem is that there are cases, and Sala was one of them, where the court, a common law fraud case, I think, could have been, a real intent to defraud prosecution would have been successful in Sala. But the point is that that's not a necessary way of establishing a felony Martin Act violation.
And on
Can I just weigh in on the discovery thing? The problem is not 3,500. Of course, you get the witnesses' prior statements prior to them testifying. Today, a white-collar prosecution in the Southern, I have a meeting tomorrow where we have 9 wiretaps, we have tens of thousands of emails, we have thousands of documents, and I'm trying to get the prosecutor to tell me what it is that they're going to introduce so I know where to look through the gigabytes upon gigabytes of information they're giving us. That is a serious problem, because you don't today, have the ability to get a judge to force the prosecutor 3-4 months before trial to give you an exhibit list and to give you the 3,500 material that early. The second issue is third-party discovery. We have the right under Rule 17 of the federal rules to go subpoena third party, but you have to establish that that will lead to admissible evidence before you see it. And so, it's a catch-22. It is really, discovery has not changed, federal or state discovery, in my lifetime. It is still trial by ambush. And that's the way it is, both state and federal. And it really needs modification. You lead to Stevens-type convictions where there's Brady material that's arguably, right now, after Stevens' the conviction was dismissed and reports were issued, there is a debate right now within the Department of Justice whether the prosecutors in Senator Stevens' case really did something wrong by not disclosing that material. Why is there such a debate? Why can't it all be disclosed? Because, this is a serious problem. They interpret Brady as something that's material to the defense. Now, that's in the mind of the beholder. Rules have to be changed.
Any other thoughts from Professor Richman, Mr. Miller?
Oh, just one piece for Mr. Waltman and one for Jerry Lefcourt. On the Fifth Amendment, the Fifth Amendment really doesn't give you very much protection as a defendant. Just doctrinally, we're only talking about the Fifth Amendment giving you protection against the government coercing you into speaking. They can get all your existing stuff. What will protect that is the Sixth Amendment or the work product privilege or maybe just discretion. So just doctrinally, be careful. If you look at the Supreme Court cases from the 80s and 70s, that will sort of answer your point on that. What you have in your file, existing stuff that you intend to put in as exhibits, they're fair game for the government, and the only bar is a statutory scheme, not the Fifth Amendment. The only thing I'll add to Jerry Lefcourt's point is that discovery's hard, and speaking as somebody who, with a case in front of Judge Grisey here, had a witness shot the day before trial, I'm really of mixed minds as to discovery, particularly across the criminal space. I know you're an elite group here. The fact is most criminal prosecutions don't concern the kind of cases you're talking about. And if you want to carve out special rules for white-collar crime, that would be interesting, politically interesting. But when you're dealing with criminal legislation, you've got to think about where criminal cases are actually brought.
Dan, nobody is talking about making discovery where there's any danger to anybody.
And you can always tell
We're talking
beforehand
about
what the danger
just
is.
in the normal case. Prosecutors know, and sometimes they're for attorney's eyes only. In this case that I'm meeting tomorrow, I have documents for attorney's eyes only, not because the defendants are any danger to anybody, but because there are wiretaps that have not been disclosed. So
the attorney in my case was the co-conspirator. We would have indicted him. He's now in jail courtesy of the Eastern District for 15 years.
thought Dan was objective.
Fascinating stuff. Well, I want to keep us on time, so despite the fact we haven't had a lot of audience questions, time for a lot of audience questions, I want to thank everyone for coming today. I want to thank our panelists for an outstanding job. I want to thank Judge Smith. I'd like to remind everyone as you're leaving, if you're seeking CLE credit, do sign out and get your certificates. Thanks so much.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.